even close your eyes, you don't have to look at the picture in front of you, is I want you to think of a recent matter that I actually watched a YouTube video on it, and I'm going to use that as an example of how complicated it is to exclude criminal liability in certain instances and how unfair it is to include it in other instances. And I want to use the example of the midwife, and some of you that watch Carte Blanche may have seen the stories over, I think there were 2 or 3 occasions where Carte Blanche dealt with this, where a trained midwife, nursing professional, was struck from the role because she started doing home births in instances where such home births were not as safe. She wasn't an experienced radiographer, so the scans and stuff that she took, she either didn't pick up on, for instance, breech births or difficulties or anything like that, or she chose not to because, it meant that she would have to send the people to a hospital where she wasn't, you know, duly registered or anything like that. So what comes from this is that a number of babies were born with hypoxic ischemia and resultant defects post-birth, including cerebral palsy. We don't know because being carte blanche, I don't tell you how many healthy babies she delivered, but we do know that there's been more than one instance of these babies being born with CP. So obviously, I remember the one mom that told her story said that, the child, she was in labor for ages and ages, and then eventually she was told, okay, the child has breached, she could feel the foot, and she was then rushed to hospital by the midwife, and the midwife dropped her off at hospital and told her, don't tell people that I was your midwife and that you were doing a home birth and etc. What I also noticed from the people that she had as patients is that they tended to be very poor. And I would think that for the most part, they wished not to go to a public health facilities and not wait. And I saw this as an opportunity to have somebody come to their house and hopefully get the type of assistance that I think they would have gotten in a health facility. Okay, so keeping that scenario in mind, we're now going to go through the slides, and I'll go back to that to explain to you the complications between malpractice that is negligence and malpractice that is intentionally harmful. So if we look at the legal definition of murder, then you would see that murder is the unlawful premeditated, that word is very important, premeditated killing of one human being by another. So it needs to be intent and it needs to be planned. Now, if we go to our midwife scenario, then obviously she doesn't plan to harm any child, and but she does plan to deliver the baby. So, in a technical scenario, in a defense scenario, she would probably get off with murder. Even some of those children have died that she delivered, but it would be difficult for the Department of Justice to show that it was in actual fact murder. Okay, and that's because, she didn't intend to kill them and she didn't plan to kill them. So if you then look at manslaughter, the word that we are most familiar with from American TV, or criminality as defined, then manslaughter is the crime of killing a human being without malice or forethought, or in the circumstances not amounting to murder. So the most common situation there that we can all think of is that somebody runs towards you with a knife. They threaten to stab you if you don't give them your phone. And in that moment, you don't even think twice. You clap them, and they fall, and they hit their head on the pavement, and they die. That would be manslaughter. So there was no intent to harm. There was no forethought. You didn't plan it, but they died. So that is manslaughter, and that is what in civil cases we would call negligence. So knowledge of harm, failure to act on that knowledge. So in that split second that you smack that person, you knew that it would cause harm, even if it was just a burning cheek, even if you intended for them to fall down, whatever, there was knowledge that it could cause harm. So that is when the negligence part of manslaughter comes in. And that is where it becomes a huge complication for the medical profession. So, negligence is a failure to behave with the level of care that someone of ordinary prudence would have exercised under the same circumstances. So, we all know the scenario of the reasonable doctor, the reasonable nurse, the reasonable specialist, the reasonable person in your position, your experience in whatever facility you find yourself in. So, if you are a nurse in public health, with 1,000 trauma cases coming in on one night, then you would be judged under those particular circumstances. Not always by our courts. They might look at you just as a particular nurse instead of taking those circumstances into consideration. But more often than not is because it's not argued correctly. The circumstances are not defined adequately. So the mores of society, or the Latin word says contra bones mores. In other words, it's something that society finds appalling. So let's go back to our midwife, her going to somebody's house, charging them, making them pay for her to do scans and to do a home birth without the knowledge and experience to actually understand what she's seeing, or to actually take them to a healthcare facility in an emergency instance. That we can all agree, I think, would be against the mores of society. I think almost all of us, doesn't matter if you are a healthcare professional or not, would be horrified by somebody doing something like that, especially after she was struck from the role. So, and then there has to be a damage causing event. So, if you are negligent but you cause no harm, then the negligence ends right there. So, it has to be negligence that causes harm. Otherwise, there's no, as we call it, causation. So, duty of care, which you are judged on as professionals, is the legal liability of a doctor to a patient. The doctor's failure to fulfill a responsibility recognized by law, of which the patient is the intended beneficiary. The first step in determining the existence of a legally recognized responsibility is the concept of an obligation or duty. You see, that's why you need lawyers, because nobody would understand that. If you haven't read it 1,000 times, it's written in such legalese. So, the legal liability of a doctor to a patient. In other words, the moment you take somebody on as a patient, and that is not linked to any contract that you've signed with them, but the moment you step up and you say, as a nurse or as a doctor, as a midwife, anybody, the ambulance guy, whoever, who says, let me help you, the moment you on an airplane and somebody's dying, they're choking on those awful peanuts, you jump up, you provide the Heimlich maneuver, you crack their rib in the process. You immediately incur legal liability. It's not to say you shouldn't do it, but your legal liability stems from the fact that you took care of that person. That's the duty of care. Then the doctor's failure to fulfill a responsibility recognized by law. In other words, legally, it is recognized that you have a duty of care, that you should care for that patient, that you should look after that patient, and that that is your duty. And you can't step away from that duty and give excuses. What I often see is that professionals get found liable for being for unprofessional conduct when they hand a patient over to another doctor and that patient then has a fallout. So I see that especially when doctors hand patients over to the trauma clinic. I know it's ridiculous, but unfortunately, make sure you follow up when you hand patients over, because often the law then, the HPCSA looks at it as if you had basically tried to give your powers of duty of care away, and now you've making it somebody else's responsibility, which they don't see it as that. The moment you start caring for that patient is your patient as primary caregiver. So make sure when you do pass them on that you continue following up, so that if something happens along the line, you can still step in, you can intervene, even if it is just a discussion with the patient. Okay, and then the patient is the intended beneficiary. In other words, the failure to fulfill a responsibility recognized by law has got nothing to do with anything else. So it's not a labor issue, it's not a crash or car issue. It's got nothing like that. It's something that the patient was to benefit from. So any other excuses surrounding why you didn't fulfill your responsibility will be frowned upon. Then the first step in determining the existence of a legally recognized responsibility is the concept of an obligation or duty. In other words, the courts, the HPCSA, the patient needs to recognize you as the person that has the duty to care for them. And here you can see is where the difficulty comes in again if you handed the patient over, even if it is to a specialist, that the patient still sees you as the person that has the duty to look after them. So if you then hand them over to a specialist whom they might not like, or who has an adverse outcome or a complication, they would look at you as the person that sent them to that doctor, or that moved them to that ward, or the nurse who didn't call the doctor, etc., etc. So that the concept of an obligation or a duty as it is viewed by the public at large under law is maybe different from how we would see it in a hospital or even a legal scenario. If I pass a matter on to a colleague because my trial runs over another day and that colleague is crap at their job, the client's going to probably never brief me again either, because they would feel that it was my duty, to look after them and not to, first of all, not to be unavailable on the day that I said I was going to be available to them, and secondly, to pass them on to somebody that doesn't know what they're doing. So it's a very wide duty of care in a professional career. Act or omission. A duty of care excess exists when it could reasonably be expected that a person's actions or failure to act might cause injury to another person. So it's not just your acting, like we used the stabbing scenario earlier on. So it's not just the fact that you clapped the guy, but it could also be because you saw that guy running with a knife towards your friend and you didn't stop him. That would be an omission. So it's failure to act as well as acting that could both be seen as being a failure to act in terms of your duty of care. You see, for instance, a colleague doing sutures that you know is going to leave severe scarring. He may be inexperienced, and you don't even bother to assist or offer to show him a proper way. I'm just using sutures as an example. That person develops a keloid scarring. They're traumatized by it. They go to a plastic surgeon, and plastic surgeon says, "Oh, but that was negligent." And the attorney that go to decides to sue everybody and his brother, and you are included in that. And the moment the courts finds out, okay, you actually saw this guy taking 10 centimeters of skin, so sorry for you, but that makes you responsible because you failed to act. So to use a silly example like that, you get the idea. It's failure to act as well as to act in a manner that could be that could cause harm, or that you intended to cause harm, that impacts on your duty of care, and that would cause injury to another person. Okay. So I don't know who of you have ever been involved in an inquest and an unnatural death, and that happens usually in a magistrate's court. It's a most unpleasant place to be. I remember my first inquest, I think I was an advocate for like 5 seconds, and it was in the middle of the winter. It was freezing cold in Joburg Court, and there were all these senior counsel that was representing everybody else. And here comes me, Peanut, that Bowman's thought us sufficient knowledge to represent the anaesthetist, and the magistrate had this like really weird little beanie on, and the court only had like 5 chairs. And yeah, it just put me off inquests for the rest of my life. But an inquest is basically when there is a criminal investigation into an unnatural death. Now, you might think that is when, the knife slipped and you cut straight through somebody's major artery and you couldn't stop the bleeding on time. But an unnatural death is classified in some instances any single death that occurs the moment from which a person enters a hospital and they get any kind of treatment and they then subsequently pass away. That means if somebody goes into trauma, they've got a massive headache, they are given Ringer's lactate, they're waiting for somebody to come and look after them, and they then have a sudden heart attack because they've been eating bacon 3 times a day. That would technically would supposed to be listed as an unnatural death because they were part and parcel of medical treatment when that happened. Every single time somebody passes away under anesthesia, it is an unnatural death and has been reported as such. So all anesthetic death and or invasive procedures undertaken during hospitalization qualifies for a referral as an unnatural death. And I'm going to stop there for a moment and tell you, you have to explain this to the family. Because if this person now gets, I think it's called the D26 form, and on their death certificate, it now says that person died from an unnatural death, the family is going to freak out. They are going to think the hospital killed that patient or you killed that patient. So you have to explain the legislation and the rules to them and say to them, doesn't mean we killed them. It just means the moment we stick a needle in his arm to put a drip up, we are already responsible for him in terms, or her in terms of a potential unnatural death. That's how wide it goes. So the pathologist is then supposed to determine the cause of death. And having read many pathologist reports in my life, I can tell you that I don't even know how they decide if it was unnatural or not, because the pathologist tends to just write the basics down of how they view every single thing in the body, and you genuinely need like specialized medical knowledge to understand when something is wrong. So with my like first pathology report, I sat there with a medical dictionary trying to figure out when are your kidneys supposed to be white and when are they not, and kidneys are pale. Okay, is that good or bad? Because that is what the pathology report looks like. And it is then, for the magistrate and for the advocates and for the pro forma, for the prosecutor to decide how to argue if it was natural or unnatural. To determine if a hearing should be held, given oral evidence, so the pathologist would then submit their report, and it's then decided if a hearing should be held, normally by the controlled prosecutor, and then to determine if there was criminal intent. So obviously, we can think back to the pediatrician that we all know, basically caused the absolute craze that everybody became scared of being accused of murder. So obviously, the pathologist in that instance felt that there was reason for it not being adequate, or maybe she didn't even feel that, and the control prosecutor just decided to proceed. So when is the arrest of a medical professional indicated? So you need to have the intent to murder somebody. I don't know how many of you know what Munchausen syndrome is. If you read Jonathan Kellerman's spy or murder novels, you will know, because he loves that as a reason why people kill. But it's basically a person that makes other people sick intentionally or kills them intentionally. So there was a movie on Netflix as well, called The Good Nurse, where this guy was deliberately swapping mates that would kill them. So that's obviously intentional. That's like borders on like a serial killer, or it is basically a serial killer. So it's you have the intention to kill somebody. Manslaughter, foreseeable harm, and this is where I explained that there's a very, very fine line. So I think if we look, for instance, at the midwife and the manner in which she deals with her patients, she may not intend to harm those babies, but she certainly has the knowledge that what she's doing can cause harm. And then you get the doctor that's in theatre. There's the possibility of a complication of any whatsoever kind, and that is foreseeable, and that could be regarded as negligence, and as such could be seen as manslaughter. So this is where the line becomes very fine, and where there needs to be a clearer definition in our law of when in medicine foreseeable harm has criminal intent. Then the inquest finds against you. Okay, so you get the idea, all of you. Sorry, these slides were quite quick, but you get the idea of the difference between the two. I just want to go to um, the civil section again. So in a civil section, just to explain civil liability to you, and you can maybe understand this from a criminal perspective as well, is that in civil liability, there's three areas that you need to look at, from which you can lose your case. So first of all, there's liability. So were you liable, and were you negligent? Did you nick something by accident? Wara wara wara. Then secondly, did you pick up that you nicked an artery? Did you immediately repair it, or did you get a vascular or anything to that effect, and it was solved? And or you didn't pick it up. There was eventually, after there was sepsis, there was like crazy stuff happening, and then as a result of that, it caused further harm in one way or another. And then as a result of that further harm, you have the patient has suffered damages. So they had to stay in hospital longer. They have future potential of fistulas or whatever it may be. So for any case in civil court to show that negligence is you liable for negligence in criminally as well, you need to show that you have liability. In other words, you should have foreseen it could cause harm, which is almost in every single time you touch a patient, there's foreseeable harm, because we all know that complications are so wide um, and so immediate, depending on the person's body type, whatever underlying illnesses they may have, immunity dysfunctions, doesn't matter. There's always the potential of harm. So negligence is part and parcel. The potential of foreseeable harm is part and parcel of what you do every single day. But if you have to start thinking about that, you wouldn't be able to function as a doctor. So when is that negligence that is a potential criminal liability? Because you should have foreseen that it's going to happen, and you have foreseen that it's happened. Have been taught that at university as a registrar every time you operate. So that foreseeable harm, how do we deal with that? In terms of the woman who goes out, who knows she can't read scans, she doesn't intend to murder, but she does. So it's only negligence, and the person that just performs their job every single day. There's a case in civil law, Van Wyk versus Lewis, it's as old as the mountains, where informed consent was found, that if you didn't get proper informed consent and there was no negligence in the procedure that you performed, then informed consent, you were not held liable for not informing the patient and getting his consent adequately. That is a very, very old case, but the judges still rely on it. In the Health Professions Council, it's a completely different story. Informed consent there is very seriously viewed, And as a result, if you have any form of, you can just not tell the full story and you're in trouble. And doctors always say to me, okay, but how do we explain all the potential complications? We can't possibly do that. Well, you have to try. That's unfortunately how it is. Okay, so we're actually going to have a lot of time tonight for questions. Lesego.
Hey, what a scary,
Did I scare you?
what a scary session. Tonight, colleagues, it seems like we might end up in prison for trying to do good because in terms of intent, I know there's, as health workers, our mental health may be affected, time and again. But my theory is that the majority of us wake up every morning to try and save the world. But in saving the world, you might find yourself in a little bit, not a little bit, in a lot of trouble. So, so Maud, I wanted to ask about competency and, to act or not to act, considering your own competency. I mean, even here, I see we've got some doctors who are actually working as managers. Maybe for the past 5, 10 years, they might not be doing calls and many other things. And when there is an emergency, how far should you go, considering that you might even question your own competency at that point in time? You try to help, you cause harm, you don't help, you are in trouble. You're always in trouble. How do we go about handling that? Mm.
I think I know that this is what one of the issues is with some professionals, is that if they do get to a situation where they may be retired and they're just trying to assist that, and then there's an adverse outcome, that they might then be accused of a criminal liability because they actually continued to perform their job. So so it's not just retirement. A minor strike, but it might have
Hi,
on.
Maud. We lost you a bit in terms of volume there.
Sorry, let me just check what's going on here. Matthias, sorry, I'm just calling my son to try and come and help because I don't know, my screen has
Okay,
disappeared again.
but it's back now.
Can you hear
We can
me?
hear you. Yeah, we can hear you. It's back. You were just saying it's not just retirement.
Okay, there we go. Okay, can you see me now? Or can you hear me?
Yes, we can hear you. We lost you when you were saying it's not just retirement, and you were continuing from there.
Yeah, it's not just retirement. I mean, we know, for instance, in healthcare facilities, especially in the platteland, there may be a consultant that gets called in that might be a GP because there's no specialist in the area, and he might have to deal with a vascular situation, be it compartment syndrome or anything like that. That might not be his specialty, and he may then be held liable for it. In most instances, he should be able to get off, but he would have to go through that long line of difficulties. And you may find that that criminally people don't see it like that, because you might find that the patient might go and lodge a complaint, or say for instance, a guy comes in with an open fracture. So now the GP is called because there's no one else available. The GP tries his best, but subsequent to that, gosh, sorry, I don't know what's happening here. Okay. Sorry, Lesego, just a moment. Okay, so basically what happens then would be that so the guy, for instance, so say for instance he's got diabetes and he's got high blood pressure, etc., etc. So he develops sepsis. He eventually loses his arm. He doesn't take care of himself properly, and he eventually loses his life.
mm,
Due to the sepsis that developed. So as a result of that, you can say that he knew that he could have caused harm because he was only a GP. He foresaw that it could cause harm. And he then, despite that, continued to provide care. And the question then is, how do you defend that? Do you then say, in a civil case, you would say, okay, if he didn't attend to
mm,
the patient in any event um, would have most likely have developed sepsis because he would have had, an open fracture. The potential of
mm,
sepsis was still there. So it's like sort of between the typical catch 22. You're between a rock and a hard place.
mm,
You treat, you're in trouble. You don't treat, you're in trouble. If you don't treat and you are not somebody that's permanently employed by the healthcare facility, you will probably get off scot-free. If you are employed by the healthcare facility, you definitely will not. Either the healthcare facility will be held liable, or you
mm,
will if you are an independent professional and you didn't even try and assist to save the guy's life. So there are instances where there are different scenarios, and it is very, very complicated in medicine to determine, you know, to actually, I cannot say to medical professionals that at this stage there is the potential, or there's never the instance where you might not be held criminally liable,
mm,
because it is genuinely something that can happen. And the biggest fear I have is, like, with the amount of press these doctors that are getting held criminally liable, is they're actually putting ideas into people's heads. It was like with the public health facility running on and on about cerebral palsy cases. Basically what it did is it made every single mother aware that might have had a hypoxic ischemic event, or delayed birth, that, oh wait, I might have a claim.
mm,
So we really should be putting a damper on this rather than try and keep it quiet. But instead, you'll find that professionals are screaming from the rooftops. Insurance companies are screaming from the rooftops about how this is something that shouldn't happen. And as a result of that, they actually give it feet, and it starts trending, and then it becomes a thing that the man on the ground becomes aware of. And what they see then as, oh wait, I can do that, I can just go and hold this person criminally liable, I can go and report them. Why shouldn't I do that? So we are actually, I mean, we advertised this talk tonight, Lesego, you and I both. We as much to be
mm,
held liable for the fact that people are now aware that, there is the potential that you can be held criminally liable.
mm,
So it's genuinely, all I can say to you is, if you get into a situation where you get that summons and it says you need to run as fast as your legs can carry you to the closest criminal attorney to assist you, and then ask for somebody
mm,
that doesn't just do criminal law, but also understands medicine. You basically
mm,
need two advocates. You need one that
mm,
understands criminal liability, and you need to understand one that does medical negligence.
mm,
And
mm,
otherwise, you're going to be in trouble. And yeah, but to defend you on murder, very, very unlikely that if you were just doing your job, that you will be held liable as for murder, because it is unlikely that the majority of doctors out there are going out there to kill patients. In America,
mm,
I would say yes, because that country's got more serial killers than anybody you've ever seen. So I would say in America, they might have more doctors that are serial killers, but certainly not in South Africa. I mean, I honestly, I've never actually heard of a doctor in South Africa that intentionally killed his patients. You know,
mm.
maybe it's just the way we grow up. We grow up suffering, so we don't want to make other people suffer, you know. So I don't know. It's just, but negligence, the potential is high. So when you go home tonight or tomorrow morning, when you wake up after a brandy and coke because you've had such a shock tonight, you can actually go and look at your insurance policy and double check that you are covered for criminal liability. And if you are not sure, phone your doctor, or phone your broker and ask your broker, you know, if you are covered for criminal liability, what amount of money are you covered for, and you know, that kind of thing. Because I
Mm.
think going forward, you are definitely going to need that because there's so much advertising now. On this thing. I see somebody there says, very, very scary, a foot away from prison. No, it's not quite like that. Trust me, our prosecutors are not very fast. So you're likely to be able to still go and hide somewhere in Reunion and get a tan before you have to come back here and go sit in jail. So, and in the meantime, you can get a proper defense. But like I always say to people with civil cases, you need to make sure you are financially stable to be able to defend yourself. So, you know, everybody looks after caring for themselves in their old age. Put money aside for your defense if anything happens. Unfortunately, there are certain professions where you are more likely to get sued than others. So, you know, if you then end up never getting sued, then at least you have extra bucks to retire with. But you have to have a fund where you deposit money every single month, um, so that you are secure in the knowledge that if anything happens, you are protected. Because I think we can all say the scariest thing is that if you are suddenly in financial trouble, is not having the money to get yourself out of there. And litigation in any manner or form, be it criminal or civil, because after the criminal case, the civil one's going to come. I can promise you that. So the scariest thing is that you know, you stand a chance of losing everything you've worked so hard for, your house, your car, the shoes you're wearing, you know, whatever it is, because you didn't have the money to defend yourself properly, or to go to jail because you couldn't afford to get advocates that were experienced enough. So money, money, money.
Hmm. Hmm. Yeah, 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 yeah. So, Doc, let's talk about, because I see there's a lot of questions, colleagues. I wonder if we'll be able to go through all of them. But the issue of helping patients outside of a hospital, where we might not be well resourced or have the right tools to help. And firstly, in terms of malpractice cover, should we have a specific cover for that? And how liable would we be to help someone in an environment where we don't necessarily have the right tools to help?
They may be covers that exclude anything you do in an emergency situation. I can't say that I've ever seen
Mm,
a policy that reads like that. But I know there is cover, for instance, that exclude your day-to-day job. To use a silly example, if you are registered as a gynae and you do obstetrics as well, but you're only covered by your insurer for gynae work, then you will not be covered for obstetrics. If
mm,
you obviously, as a gynae in an emergency situation, perform an obstetric procedure, that is obviously a motivation that you can provide to the indemnity professional as to why you should be covered. And you certainly have a constitutional duty to assist somebody in a situation like that. So I think there are certain grey areas where you certainly can make out a case for why you stepped out of what you are registered for professionally. But I would think an ordinary GP, well, I say ordinary, but a GP, you, I mean, GPs that work in the platform know everything, you know, because they have to deal with everything because there's just not enough specialists. So, you know, if that GP then helps with a pulmonary embolism or whatever, they certainly would not, the insurer would never say to them, I'm sorry, I'm not covering you, um, because you stepped out of your speciality. The Health Professions Council actually does not require you to be a specialist in a particular field to perform a specific procedure. Um, if you advertise to be a neurologist or a forensic psychiatrist, etc., then you need to be registered as such. And if that is all you practice, but if you are somebody that are active in a number of fields, for instance, in public health, I'm sure that there are a lot of medical officers that practice in many, many different fields, then you will not be held liable for doing something that you may not regularly do. I mean, that's like for me, for instance. I mean, if you now send me to criminal court, I will have to find a friend to ask them how criminal procedure works. But, it doesn't mean I can't do it, or I can't read the book on criminal procedure because I did study it, I did pass the exam, and I did, so there's the difference there. If I, however, start advertising as being a specialist in criminal law, I will get into trouble. I will get reported by my colleagues, and I will say, you've never done work like that. How can you now advertise yourself as a specialist in that field? So that is the reason why advocates never ever say that we are a specialist in a particular field, unless you are genuinely a specialist. You would say that I have a special interest in a particular field, so that you don't get into trouble for saying you're a specialist. So.
Thank you. Yeah. And is there a way then to differentiate between a procedure that failed versus maybe negligence from the person who was doing a procedure? Or is one and the same? I'm the one who's
Yeah,
inserting catheter, and if things go wrong, it's always the clinician. We don't necessarily look at, I don't know, because procedures do fail, even
Yeah, no,
if
look at that. And
correctly
this is
sometimes.
where I think, this is where for me the danger comes in, is that we cannot go out there and say doctors cannot be held criminally liable for negligence, because there are clearly cases like our midwife case where, that what she's doing should be criminal, even though it's negligence and not murder, it should be criminal.
Mhm.
But so any negligence that is an adverse outcome or a complication is defensible. In other words, I will stand up and I will defend you, even if I pull all my hair out of frustration, I will do it because I would know that I would be able to get you off most likely. But
Mm,
if it's a complication, for instance, and you don't attend to the complication and the person passes away, there could be criminal intent there, because there was foreseeable harm, you knew
mm,
that it would cause harm, and you didn't do anything. So then that fine line becomes closer to the red. You're standing between the black and the red, and that gray in between, you're starting to move closer to
mm,
the red. So it's in every single case, be it murder, be it negligence or manslaughter, there's always the facts of the case
mm,
married to the clinical side of the case. So you have to always look at both of them to be able to determine if
mm.
there was liability.
Super. Colleagues, we are going through the Q&A. It's easier there. Anonymous talks about that he is a registered paramedic, but because where he's working, they no longer provide ambulance services. He's been told that he's not allowed to assist any patients at any scene while on duty. Will he be held liable for negligence for failure to act?
Well, it sounds like he could get fired rather than be held liable for negligence. So, in that instance, what would most likely happen is that, if you are employed by somebody, they are vicariously liable for your actions. So, if they're not
Mm,
providing ambulance services and he then continues to provide it, and his employer is then held liable because he's employed by them, that is what is called vicarious liability. His
mm,
employer can then turn around and say, they most likely will still defend the case, but they can turn around and say, okay, we're claiming all this money back from you
mm,
because you were specifically told that you're not supposed to do it, or you will get fired on the spot, and you probably, well, you will have to have a very sympathetic CCMA arbitrator to get off. So that's probably the kind of case that you would have to take to High Court, and you would then have to argue constitutional principles and say that, you have a duty of care, and that constitutionally everybody is entitled to reasonable care, healthcare facilities. So there are ways in which to defend it, and I would certainly would like to take an employer like that to court. So feel free to call me if that happens to you. But so there's always ways in which I can defend people that
mm,
have not intended to do harm. But at the end of the day, it's going to be a long process and it's going to cost you money. So that's why I'm saying, if you are worried and you are concerned, I saw somebody earlier on saying, is this profession even worthwhile? Yes, absolutely, yes. Sometimes I don't get paid for 6 months. It's still worth doing what I do.
mm,
And so you just need to make sure you have the resources to be able to defend yourself if something goes wrong. And you shouldn't stress about it because you are adequately covered. If you
mm,
don't have indemnity insurance, then you need to, like, I know you laughed the last time I said this, Lesego, but you need to have an extra house that can pay for your
mm,
litigation. So make sure that you make provision for that before you make provision for your old age, because then if nothing goes wrong, you can use that money for your old age. Otherwise, you're going to die from stress anyway, and then you won't see that money you saved for your old age anyway. So to try to alleviate this stress, you need to
mm,
be financially secure in the knowledge that you can defend yourself no matter what happens.
mm. Yeah, and then hey, doc, you see today I call you a doctor, advocate. May it be. So, because every
That's a
time,
massive sign, so
I
fire
mean,
me.
yeah, I mean every question and then every answer to the question, there's like 10 more questions. But I want to stick to the Q&A so that we try and go through as much we can. So, in terms of rephrasing Sibuti's question there, in terms of informed consent, how do we how do you decide what you need to tell the patient? For example, you are going to give a drug. I mean, there's like a whole lot of side effects. There's common things, there's rare things, and rare things do happen, and now you are in trouble because you didn't mention it. How can we handle that?
I think, and you know that I always say this, Lesego, is you need to get to know your patient, and it only takes 5 to 10 minutes to quickly, even shorten than that if you speak as fast as I do. You only need to ask a few questions, like,
Mm,
what do you do, where do you live, what do you do for what is important to you in your job, what are your hobbies, what is the
mm,
outcome helpful with this procedure. So you know that I've in the past, and some of you might have been at that talk as well, have used a lady that had to get a parodectomy. She wasn't told that her voice would be hoarse for 6 weeks after that, but her job was as a call center operator, and in the process, she lost her job, and she then went for collagen injections with an ENT that didn't know she had a parodectomy anterior entry, so it prevented her from ever healing. So that would have been, if you had just asked the patient, okay, what do you do? Oh, I'm a call center operator. Oh, poop, I'm about to push your voice box into all directions here, and you actually
mm,
won't be able to talk for 6 weeks. Let me write you a sick note for 6 weeks. And,
mm,
if you still can't talk after that, because sometimes it can take a year, we'll, claim a medical pension for however long. So there's ways of dealing with what is really a complication, and if it takes longer than 6 weeks, an adverse outcome. So if anybody had asked her, what do you do, she would have been able to say, okay, this is what I do. You go for, I had a matter where the patient was an avid long distance hiker, heavy backpacks and all of that. And she had a knee op where she wasn't informed that one of the rare but potential complications is an injury to the nerve and a drop foot, either minor or severe, which could impact on her hiking.
mm,
That totally ruined her life, so that rare complication, if they had just, or what do you do as a hobby? Oh, I hike up and down, I cycle, okay, then I must tell you that this knee op, not only will you potentially, because you're super active, have to redo it in 5 to 10 years or 10 to 15, depending on your age, but it's also the potential of this complication that could prevent you from hiking in future. So do you want to try and last a little longer, until you're a bit older, or do you want to go ahead with it? So those are the simple questions that to
mm,
me is proper informed consent. Know your patient, even if it's somebody you see for the very first time, even if it's somebody that was forwarded to you by another doctor, just quickly ask those few important questions. What is
mm,
important to them? That they might want to know. People don't listen to you when you tell them about complications that's not of interest to them you know
mm,
so if you tell them, okay, one day when you're 100 your leg's going to fall off, most people don't think they're going to become 100, so they're not going to listen any further and they're going to completely forget, and then they actually become 101 and suddenly their legs falls off and they're going to say, oh, you never told me, because at the time it wasn't within the framework of contemplation. So use what is within the framework of contemplation to get proper consent.
Colleagues, I'm looking at the chat and I see people are in so much pain about our profession. Ndebogeng saying maybe these lectures should be given to grade 11 and 12 students before they decide to jump on board because, wow, this career. Nothing
Mm,
great happens, colleagues, because we are great people. We will always have challenges and pushbacks. But I know how it feels. I know how it feels, colleagues. Koroshi says it's not worth it at all. But for the majority of the people we care for every day, it is so worth it. It is so worth
mm.
it, colleagues. But these challenges should not pull us down. But Maud, now I want to ask this question differently. Uh, am I obliged to always identify myself as a doctor? If I'm at a soccer match, at church, at a conference, in a plane, and they say, "Is there a doctor here?" Do I always have to identify myself as a nurse, as a midwife, or I can just say, "Ah, let me not."
Well, I think if the person's about to drop dead, then you probably have a duty of care to actually go and say, okay, let me just press on the chest a few moments until the ambulance arrives. But I mean, I can use myself as an example there. I would go to school functions and
Mm,
people would ask me what I do, and I would just say I'm a lawyer. I would never say I'm an advocate. And it's only if they then ask me which law firm I'm at that I then have to, no, actually, I'm an advocate, and then they sort
mm,
of look at me and like, no, lawyer's not an advocate. Actually, lawyers include attorneys and advocates, but I prefer not to say because people literally take a step back, you
mm,
know, when I
mm,
tell them I'm
mm,
an advocate. Like they would be talking to me and like, what do you do? I'm an advocate. And I'm like, I can see them like move backwards. Like I exude some kind of scary presence or something, So I feel you when you say, should you always identify yourself as a doctor? And that is
mm,
so sad because, we've worked so hard to be where we are. We should be proud. We should be
mm,
able to jump on the tables and shout out that, this is what we do every day. But people see it as an accolade, a badge of honor. They don't see the hard work and the time that goes into it. It's like somebody
mm,
said to me the other day, oh, they're so tired. They worked from 6 o'clock till 8 o'clock today. And I was looking at them, I'm like, dude, do you even know what hard work is? Do you know how many times in my life I've only slept 5 hours? You know, do you know that I actually, when my kids were little, my body would wake up after 5 hours of sleep because it was so used to it.
mm,
So people have a complete different impression of what hard work is and what you as a doctor do, and
mm,
money they think you make versus the work you do. You know, they
mm,
don't see all the work you put in for free. They don't see
mm,
all the stress you don't get compensation for. You know, all the emergency procedures, all these things that you have to think of, which somebody that is executive of a business that gets a massive bonus at the end of the
mm,
year when the ATM still doesn't work at the bank where he's the chief, you know, and you sit there and you think, you know, I save lives and I don't even have that kind of money, you know. So people on the street have a different impression from us. And I know
mm,
that as a defense counsel, I've many a times gone up to plaintiff attorneys and I've told them that guy that you're suing, he doesn't have insurance, leave him now. And sometimes
mm,
I do. Sometimes I drop him because I know they're not going to get much money out of him. You
mm.
know, so I must remember
That's
to
sad,
tell.
actually. So it means,
No, there's one professor that I defended a few times for. You know, he's
mhm,
just in a high risk position, or he's got a high risk speciality, and he then dropped his insurance at some point, and I saw one of the big law firms has a case against him. So I went to them afterwards. I said, "You know, he doesn't have insurance." You know,
they
and
stop
because
outright.
I knew they wouldn't proceed with the case if I told them he doesn't have insurance. So, you know, so sometimes there's other ways to beat them. You don't have to be good in court; you just have to be
Yeah.
clever.
Okay, but there's a Dr. Chetty there at 1903 is the question. He's commenting about the pediatric surgeon's case. Would you like to maybe go through it so that you can follow what he's
Look,
saying?
I can't, you know, I know Dr. Chetty and I have talked on LinkedIn quite extensively, actually, about
Mm, mm,
various aspects. I
mm,
know, hi, Ranesh, I know you're very passionate about these particular cases. I think the difficulty, because I've also spoken to other professionals that feel differently. You
mm,
know, so in any case, in every case, there's people that are for and people that are against. I think we can say for 100% sure that no doctor feels that that was murder.
mm,
You know, but there are doctors that feel that he shouldn't have continued working. And I think the biggest thing, and I can't say he should or he shouldn't have. I'm not
mm,
defending him. I don't know him. You know, I don't even know how well these people know him that say that, you know, and it can be complete hearsay. But all I'm saying is this, that, again, I take it back to the fact that there are facts and then there's the clinical evidence. So
mm,
we certainly, a doctor that has performed a job without the intention to kill should never, ever, ever be held liable of murder. I think
mm,
that we can all agree on. Should they
mm,
be held criminally liable for negligence? Yes, in certain instances, we cannot get away from the potential that, you know, that that person may be criminal in the fact that they are negligent.
mm,
And that is where, you know, if they change the law, we are going to have difficulty in defining it. It will take many think tanks and many times getting together to actually refine that, you know, to say, okay, in which instances, and even then, there will be prosecutors or attorneys that can get around it. So that's why I'm saying, look at the potential of being held criminally liable for negligence as a real potential and save
mm,
money. You know, so
mm,
I promise you, probably the majority of the time you will get off. You know, and if you don't get off, then you probably we can go all the way to the constitutional court with it and argue it there.
mm.
You know, and try and change the law because it's the only place you can go to change the law. But yes, be careful of patients now starting to see negligence as criminal.
Mm. Yeah. Okay, I think
The safer
okay,
if
on
you
a lighter
guys, I
note,
would have given you a hug now.
No, it's tough. I can see how clinicians feel in the chat. Yeah, but it's yeah, we are being empowered, and I think it's Dr. Antlopi. He said we should always try to do our best, and be very reasonable, And I think maybe
Yeah.
that should always be the goal. More on a lighter note, everyone is protecting the public. Who's protecting the health workers?
Well, that's where I spoke to your friend, one of your prolific speakers on occupational health,
And he's
our
here. Thank you, so.
yeah, at our fabulous ball last year, is that we really need to start doing something about getting that
Mm,
occupational healthcare for healthcare workers to be implemented, and maybe that's something we should look at to bring an application like that. To say, look, it's not being done. Healthcare workers are not being taken care of. Those of
mm,
you that have attended CCP's seminars on looking after yourself, it's super important. I mean, for us as advocates as well, a very common thing for advocates, and I'm saying this in the sense that it's more than one, is suicides for attorneys and advocates because the stress is so high.
mm,
So we now openly sit around the coffee table in the mornings at court and discuss which anxiety meds we're taking. So if you are stressed, talk to
mm,
somebody about it. And don't be embarrassed about it. Mental health should be as common as the common cold. We should be able to discuss our mental health with each other because everybody would understand what you're going through.
mm,
And be able to say to a colleague that, yo, I had a tough day today, XYZ happened. And it doesn't, I think people on the street would accept that if there was a death of a patient, that would be stressful. But sometimes it's not the death of a patient, it's that patient that walks in there who have just been told by the bank that they're taking his house. And now, you're touching him in the wrong way that now goes and report you. So it might not even have been personal. And that person stresses you out so much because you so strongly feel you had done nothing wrong.
mm,
You need to be able to deal with that. You need to be able to put it to one side and you need to be able to say, okay, I'm going to put it to one side. I'm going to say, okay, this is what it is and I will deal with it when I need to deal with it. I think this is something that I learned over the years because and I think a majority of women have that problem. We overanalyze every situation.
mm,
Is I've
mm,
learned to just walk away from it. Yeah, it happened. So what? I can't do anything about it. And then if it comes around and I have to deal with it, then I deal with it. But to think about it day and night is almost like to call the spirits to pour it down on you, all that terrible stuff. So turn around and say, okay, that happened. I've informed my insurance. I've spoken to somebody at work. I've taken proper notes. I've gone back to make sure I have proper notes.
mm,
So now I can carry on with my job. And if it does come back to me to bite me, then I will deal with it. But don't. If you start carrying things like that all the time, it's like when I first became an advocate and I lost a case, I swear I lied awake for the next 3 weeks wondering, even if
mm,
it was just an unopposed motion, wondering what I did wrong. And then I realized, okay, what you do is you go back to the office, you discuss it with a senior. What did you do wrong? Okay, that's it. Make mental notes, off to the next one. But if you
mm.
carry it with you, for the next month or whatever, weeks and ever, it will kill you.
Mm, mm. So there's a question I want to ask. I want to find the best way to because we've also seen if people don't get it through the justice system, one get a sense that sometimes, I don't know, the families may take the law into their hands because we've seen also health workers, I don't know, being murdered, for a lack of a better word. Obviously, we don't know why, but one suspects that it probably comes from families who feel that I don't know, maybe they didn't get the justice. It's my suspicion because I don't know if it's factual what I'm saying, but I've seen a number of
Mm.
specialists being shot and stuff. Is there is there a better way on our side on how to handle these issues when there is a case against you, such that, I don't know, the family still feels that um, I don't have the best way to ask this question,
Well,
but
I
I'm sure
would
you,
think,
you, you hear
yeah,
what I'm trying to get to.
no,
Yeah,
no, no,
because
I
it's
absolutely
painful
hear.
when you see it. Yeah, yeah.
Yeah, and I think in a situation like that, the moment you've got a large family involved, which in
Mm,
certain cultures is more common than in others, you sit them down and you say to them, you would like to bring in a mediator, you speak to the hospital if you're employed by the hospital. If you're in public health, maybe suggest it to the hospital manager and get everybody together and do a mediation. A lot of the hospital managers
mediation.
would arrange
Mm,
something like this themselves, but people often feel that the hospital is out to protect the doctors, which they probably are, especially if it's somebody that has a super speciality that they need in their hospital. So ask for an independent mediator, even at the hospital bed. That's one of the things I'm super passionate about is bioethical mediation, and it's one of my specialities as a mediator. Is
mm,
call me even if I don't live in your city, and I'll send you details of somebody that can come
mm,
where the patients are, where the family is, and try and just dissuade a scary situation. I mean, we've had how many attorneys getting murdered on the steps of court by angry husbands, who feel they didn't get the kids or whatever. In actual fact, matrimonial attorney is probably the most dangerous job as an attorney
mm.
because that
Mm.
husband doesn't get what he wants, he just murders the attorney. So there are instances where you need to tone the aggression down. And if you yourself have tried and failed, get somebody that's an independent third party that can assist you. Gosh, that's a horrifying picture. Let's say, I
Mm.
only saw it now. The
So you
stethoscope
mean your
and the
picture?
cuffs. Where did you get that? That gives me anxiety.
But I just put it because you were saying that mediation is your space.
Yeah.
You wanted to just people to read your profile so that also colleagues, if you are going through something related to malpractice in the health space, Maud is the person to go to because she's got a lot of experience. Even when she speaks, you can hear that in terms of medical terms and stuff, she's on board, but she works to defend. Her biggest task in this world is clinical defense. So she can also link you up with a lot of resources. And I know that she also does a lot of pro bono work. I'm not saying go there and say I need pro bono. If you are able to afford the services, please do so that she can keep going. you know. Mod, at 1905, there's a question by Anonymous where Anonymous gets into a partnership with a colleague who has started a lab. The lab is not accredited, and now the later on they find out that the HIV testing results were inaccurate. So some people were told they are positive when they are negative, and so on. Now, and yeah, so who's negligent there? And remember now, there's the doctor who has referred the specimen, then there's the lab which was not accredited, then in the lab there's partnerships. I think everyone, in my view, because you have a
Yeah.
responsibility to verify.
Well, well,
Yeah.
I think it would start first of all with the doctor that refers the patient on. If he was aware that the
Mm,
lab is not accredited,
mm,
then yes, he's liable. If the lab is not accredited, definitely the lab and every individual person that performed procedures will be held liable. And
mm,
so I think. Well, if you say to somebody, okay, I'm going to refer you to a lab that's not yet accredited, so you may have a higher false positive because, I mean, false positive is not impossible, as you know. So the instances of false positive might be slightly higher or false negatives in that lab. However, you stand a chance of getting your results faster, or et cetera, et cetera. So if there's benefits to sending
Mm.
them to an uncredited lab, then just make the patient aware of it. If there's no benefits except maybe the
Okay.
kickback you are getting, then just don't do it.
There's no benefit, but there can never be a benefit. We have to do due diligence and ensure that
Yeah.
when we
Well,
partner with people, everything is in order. And yeah, because
yeah.
you'll always get caught.
Yeah,
Mm-mm-mm.
look, I can give you an example of a matter which where the HB says I did find the doctor liable, and that was where he employed a locum that was not registered, even though this locum had been working for public health for 30 years. It turned
No.
out that he was in actual fact not registered with the HBCSI for the past, say, 12 years.
Mm.
And he then had an adverse outcome with a migraine injection. And instead of going after the doctor that was not registered, they went after the doctor who employed him.
Mm.
So that's what I'm saying is that the Health Professions Council, if you refer patients to a practice that's not accredited, even if you were not aware of it, will hold you liable.
I don't know that one. I think we have a responsibility to always ask for the
Yeah.
documents and verify. Now, Maud, I don't know how much time you still have. Let me know if we should wrap up. Maybe we can take
No, it's fine. We can go till
one or
8.
two more questions, colleagues. We won't be able to go through all of them, but maybe we can do a Q&A session with Advocate Maud and go through some of the questions on a different session. There's the issue of health workers who have to work under supervision in terms of the many laws. If the intern ends up making a mistake in this context, who should take accountability for that? Is it the intern? Is it the supervisor? How does that work?
I think, again, we go back to vicarious liability. So that means that if the intern is employed by the facility, so for instance, the state
Mm,
health facility,
mm,
um, it's in actual fact probably irrelevant if it was the intern or the specialist who performed the procedure. There was negligence, and the state will be held liable for that.
mm,
In a private healthcare facility where a person is a trainee, I would say, or inexperienced, I would say that you have a duty to inform the patient, and it should form part of your informed consent. And
mm,
should your patient then later find out, and it may just have been a complication and not even an adverse outcome, that the person was inexperienced and you didn't tell him, you probably will find that you have a complaint or a civil action against you. So I think that you need to look at those two different scenarios. I think all of us that use private health, I mean, I use public health and I don't ever expect to be treated by, or my parents to be treated by, the most experienced professional.
mm,
If I'm briefed as a junior advocate, like I mentioned earlier on, it was my very first inquest. I'd been an advocate for 5 minutes.
mm,
Everybody knew, that was there. All the senior counsel, the attorney knew, MPS knew, that was briefing me, but they trusted me. So we can't all. Those of you who follow me on LinkedIn would have seen. I recently posted that we all have to start somewhere, and it means everybody will make a mistake,
mm,
and that you don't just learn from your own mistakes, you also learn from other people's mistakes. So a
mm,
reasonable person would accept that there at
mm.
some point would be somebody involved in their healthcare that's not a super specialist. But I think it is important that we tell patients if that person is going to be part of a team that can have an impact on the outcome of the procedure.
So not as a quick one, as a follow-up on this one. So if I'm an int, if I'm a trainee, should I identify myself as a trainee, right, to the patient?
I think, okay, let me give you a quick example of something I've personally experienced. Is
Yeah.
My mom needed her drip replaced or she needed a drip. She was promised a drip. She was in a severe pain due to an obstruction. I was eventually screaming and shouting at the nurses, and they were ignoring me like chopped liver. And eventually, somebody told me that no, only second year registrars are allowed, or first year registrars are allowed to insert drips. So that is obviously, was information that calmed me down, and it was something that I knew was important. So yeah, I wasn't too happy then when I walked past the doctor's lounge and I saw all the registrars having a fat chat and a cup of coffee. When my mom was in pain. But but
Uh,
yeah, you get the idea. And that's why I always, as part of my lessons, tell people, or as part of my workshops, make sure that when you are having tea, cake, and coffee, don't look like you're having too much fun, because patients will hold you responsible for that. Let's say who's now on a tea break. Let's say her. You need to come off your tea break. We can't hear you.
Oh, I've muted. Sorry. And I asked you
You
two
see,
questions
now
already.
we're
I'm
all going to
busy
hold you
talking,
responsible for that.
and you know how I know? I'm looking at I'm asking, why are the people laughing? And when I check, I'm muted. Everyone is like, sharing an emoji and they're laughing. I'm like, okay, what's the joke? Anyway, but I wanted to ask on behalf of public servants, the health workers there. I know most of them malpractice because I also work with some of the provincial. They're generally directed at the MECs. People sue the MEC.
Mm.
Should a public servant consider malpractice cover? Is there a benefit of that, or they are just protected by the state?
They are insurance companies that provide free cover for any registrars. So anybody that has not yet completed the training get there's one insurance company. I don't want to mention them here. You can do your research, but there's one
Mhm.
insurance company that provides free cover for students and people that are still in training. So even if you are a student, that gets free cover. Obviously, that helps you when you later on have to apply for cover, because you then have existing cover in place. If you are a public healthcare worker that moonlights, even in a case where you are a good Samaritan, I would say rather get cover, even if it is the lowest possible cover, rather get cover. Then something that I saw once a letter from who at the time was the hospital manager for one of the big public health facilities, where he sent a circular around telling doctors and nurses is now going to start claiming money back from them for mistakes that they made. Now, that is actually legally allowed. So, in a situation of vicarious liability, in other words, where the state has to fund the litigation and any adverse outcome, that they can recover those monies from you as an employee if you were negligent.
Mhm.
So there is that potential. So I think if you are in a high risk scenario, rather get especially if you're not planning on forever being in public health. Then it's always better to start with a low cover, even if it is just a basic cover, so that when you then leave public health one day, you can say, okay, I've had cover for ABC years and I've had no adverse outcomes.
Nice. Interesting. Maud, I think from my side, I'm gonna close with this scenario because I was just browsing through. So, in terms of disclosure for protecting other people, so you have your patient who has an infectious disease, which is infectious, and they do not inform let's say, for argument, this is HIV. They do not inform their sexual partner. The sexual partner becomes infected. Can the infected can you be held liable as a health worker for not disclosing to the people at
No.
risk?
No, because HIV, to use that as an example, is one of the
Mm,
most protected instances in our healthcare. So somebody telling you you're not allowed to disclose my status, that is absolute, and that is the same with any. If you have cancer and you don't want them to tell your family, it's protected under the Code of Ethics of the Health Professions Council, the
mm,
South African Nursing Council. It's protected under the National Health Act.
mm,
It's protected under POPIA. So it's protected under so many places that your healthcare is private. We went to court once for a doctor that whose site was affected after a vaccination, where it is a rare complication, but it is a known complication.
mm,
And the request from the pharmaceutical company was for all his hospital record or for all his patient records to determine if he didn't get measles from one of his patients. So we went to court to argue that he's not entitled to the names of the patients
mm,
because they have a right to non-disclosure, but that we can provide the documents to him redacted and without any personal information. And the court agreed with us, and we were allowed to provide patient records without any personal details to the other side. So that is how important it is, and we've even now started using that. Well, I've started using it with the medical aids when they start asking for like 500,000 patients, some of whom you've never even heard of, whose records they want. I just say to them, okay, well, please send me the portion in your contract where this patient agreed to me sharing their stuff with you.
mm, mm.
Otherwise I need to get consent. So yeah. If you say
Yes.
medical eyes, my face wants to, I become like a bullfrog with anger. So,
Yeah, we need to revisit that topic.
oh,
I know
it's
there's
even
a lot
more
of
frustrating than doctors being held criminally liable. I can tell you that.
yeah, yeah. Ah, Maud, this is it. I think colleagues, we have really tried to go through all the questions. My apologies if we have not managed, but I hope importantly you have managed to understand the principles and your role, your responsibilities, the decisions you have to take today to protect yourself, your family, your estate, yeah, and to always try to do your best within the available resources. I'm hoping we are planning with Maud to try and have these ethics sessions regularly. I'm hoping she still has the energy to keep going because you guys are attending, you are asking a lot of questions, but please just remember that we are called to serve many, many, many people. Rely on us for their health and well-being. Let us not deny them the opportunity or the care because 1 in a million is going to want to cash in. But many, many, many people really appreciate our service and our profession. So, Maud, after all these discussions, what do you want us to really take home? And yeah, thanks, Maud, advocate.
Save money.
Buy another
Save
house.
money to defend yourself when you have to, because I promise you, when you have money in the bank to defend yourself, you will be immediately less.
Yeah.
Stop
Colleagues.
buying, stop buying that Porsche for your wife or for your husband and save that money.
Yeah, colleagues, I think that's it from us. Just remember to visit our website as I share the link. Become a member. 1,200 gives you access to over 144 CPD accredited events. You'll have a peace of mind, but importantly, you'll be the most up-to-date health worker in the room. And that means even when things go wrong, when we want to verify your competency, you can always ask us for your CPD report and we will issue it. And I'm sure the judge will see, well, okay, this one, he's committed to his or her professional development. I tell you, they do check these things. Colleagues, may you have a peaceful night with your families. Good night, colleagues. Advocate, as always, may the good Lord richly bless you. Bye, colleagues.
Thank you, Lesega. Bye, everyone.